Good morning, Matthew. This is Donna Zedler. I listened to your post on how you feel that this course hasn't changed your opinion on entrepreneurship and liberty. While I can see some of the reasoning behind your points that you make, I feel that I need to tease them out a little bit more and argue in favor of entrepreneurship as an expression of liberty. You state that you feel entrepreneurship was used to restrict freedom during the 1960s in America and prior to that during the period before the Civil War or the antebellum period. Starting with antebellum America, I assume that you're equating farmers or southern plantation owners with entrepreneurs. While certainly due to the fact that they were reliant on market forces to sell their products and operated independently of a larger entity that would make them entrepreneurial. But I think that democratic southern farmers would argue that their agrarian way of life set them apart from the entrepreneurs of the North. Business concerns in the North needed wage labor in order to produce their products and fill their factories, making them more amenable not only to working people of color, but to women employees as well. I think that if you're looking to place the blame for slavery as an economic system on something, you would have to look at the government. The founders and framers of the Constitution tended to assume that slavery would peter out on its own with time, left untouched by any laws that limited its growth, but this is the opposite of what happened. It actually became even more entrenched as a political power. During the period which extended from the ratification of the Constitution to about 1850, slavery was the third rail of politics, meaning that whether you were a Whig or a Democrat, you weren't allowed to touch it as an issue. There were great fears that disunion would come of any attempt to regulate slavery, and no one wanted to trigger such a break. Both political parties tried to court what was called the slave power because the desire not to lose those constituencies was very important to them. This led to internal congressional policies such as the gag rule, which happened during Martin Van Buren's administration. This prevented petitions from anti-slavery constituents to come to the floor of Congress. Hostility toward abolitionists and other anti-slavery movements continued until the establishment of the Liberty and Free Soil parties in the elections of 1844 and 1848. These parties, comprised of Northern abolitionists and anti-slavery forces, pointed the finger at both parties for their inaction on slavery and demanded a halt to the Western expansion of slavery in order to ensure that it would be a free land, open to the entrepreneurship of settlements and exploration, unencumbered by the stain of slavery. Now, in consideration of your discussion of Lester Maddox and segregation in business, hence entrepreneurship, I would argue that as a system, entrepreneurship tends to lend itself toward tolerance and inclusiveness because the opposite would close off markets for products and limit markets. In our text, it points to the fact that entrepreneurship was self-desegregating. Markets, even in the post-Civil War South, showed a propensity to be colorblind if the return was high enough, say the authors. They point to a study by Jennifer Roback that showed Southern streetcar businesses voluntarily desegregating in order to foster a positive business environment until the government stepped in through Jim Crow laws and forcibly segregated them. Although the government did, through the civil rights legislation of the 1960s, finally right its wrongs regarding race in America, business has always trended toward inclusiveness. Lester Maddox is an outlier and he's an exception to the rule, and he shouldn't be used to indict all of entrepreneurship as exclusionary or limiting of liberty. I think it's important to bring this discussion forward a little bit more as well, to discuss government intervention in business which might violate people's consciences as well. In our day, we've seen major court cases with regard to the right to conscience in business as I lost my place. And this has not always turned out well for entrepreneurs. Whereas the Civil Rights Act guaranteed that someone like Lester Maddox couldn't refuse to serve people of color, government imposition has also called into question whether Christian companies or other entities run by those of religious faith have the right to discriminate or otherwise hold policies that violate their right to conscience. My first example is the case of Jack Phillips of Masterpiece Cakes, who refused to create a wedding cake for a homosexual couple because it violated his Christian beliefs. He was accused by the couple of discrimination. Colorado law did not protect Phillips because of its inclusion of sexual orientation in its anti-discrimination laws. But the United States Supreme Court overruled that decision under First Amendment grounds that Phillips was within his rights as an artist in refusing to speak for a lifestyle that his religious beliefs found offensive. I think that important discussions of federalism will follow this ruling, and also this decision is only expected to be applied under very narrow First Amendment grounds. Another modern case which touched on conscience was Burwell versus Hobby Lobby, which claimed that the corporation's refusal to provide particular forms of contraception via its health care plan was a violation of the Affordable Care Act. The court ruled that closely held corporations, which would certainly indicate entrepreneurs, cannot be forced to offer contraceptives which violate the conscience of their proprietors. Large religious-owned entities such as Catholic hospitals were already exempted from the coverage requirement under the ACA law. This decision was made not on a First Amendment ground, which was the Masterpiece Bakery case in the Supreme Court, but under a law called the Religious Freedom Restoration Act, or the RCRA, which states that governments should not substantially burden religious exercise without compelling justification. Again, whether entrepreneurs and other businesses will be liable ultimately to state laws which either limit or expand liberties, or to federal laws owing to grounds under the United States Constitution, remains to be seen in the long run. In any case, Matthew, I hope you found my comments useful and that you are enjoying the course. Thanks so much. Bye.